Come here. You, ahí. Tu caso ya tiene 215 días. Te voy a dar una semana para hablar con un abogado de inmigración para ver qué va a pasar. No te doy más tiempo. ¿Me entiendes, Méndez? Una semana. All right.
Okay. Thank you, Judge. Appreciate it.
Let's roll, nerds. All right, you're Thomas Flores?
Yes.
Mr. Flores, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Okay.
On March 11th, 2025, officers observed a vehicle speed past their vehicle, shaking the patrol vehicle due to the high rate of speed and run a red light. The officer observed vehicles traveling on the green light slam their brakes to avoid hitting the defendant. The officer also observed the defendant weave in and out of lanes 3 times without signaling. A traffic stop was initiated. The officer advised the defendant he was being detained for reckless driving. The assistant district attorney accepted the charges, and the defendant was advised that he was being placed under arrest and needed to exit the vehicle. The defendant refused to exit the vehicle and stated the officers would have to break the glass to remove him. Officers made entry into the defendant's vehicle and placed the defendant in custody.
By chance, you know how fast? Does he say? Because he says a high rate of speed so fast that the car shakes.
Yes, and that's all they have in the DIM summary, Your Honor. And then it's him running the red light, causing people with the green light having to slam on their brakes.
Okay. Mr. Flores, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run his license, please?
Yes. His driver's license is eligible, Your Honor.
I'm ordering you as a condition of your bond not to drive in this manner again. If I see you drive like a complete maniacal person, I'm going to take your privilege drive away, and then I'm going to put you in jail. Do you understand? I will protect my street at all costs. If that means putting you in there with an extremely high bond, I'll do it in a heartbeat. No reckless driving, street takeovers, donuts, anything of this nature. Do you understand? You are also not allowed to drive unless you have valid liability insurance in your name as well. All of these are your bond conditions. We'll have you sign these bond conditions now. You pick up a new case if I find out anything. Do you understand? Now, because you have a lawyer, I will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with counsel. If he tells me he can't get a hold of you, you pick up a new case, you act like a bonehead. It's not going to go well for you. Do you understand? All right, I'll have you sign a reset with Victoria. We'll have you meet take a seat in the jury box when we get your bond conditions. We'll have you sign it, and then you'll be free to go.
Thank you, Your Honor.
Thank you, Your Honor. So do you mind filing those conditions?
Do you want the case number?
Yeah.
55528. Lundy, come on up.
Morning, Your Honor.
That way.
Well, good morning. Top of the, it's Friday Eve.
Yes, happy Friday.
Wednesday.
Did you get it? The cost number?
Yes, I did.
Okay. Good morning, Mr. Lundy. Sir, you're charged with failure to stop and give information, which is leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 12th, 2025, at approximately 4:45 p.m., an officer was dispatched to an FSGI call. Upon arrival, the officer spoke to the complainant, who stated he was traveling north on FM when a vehicle crashed into his vehicle. The driver then fled the scene without exchanging information. Complaining witness to the passenger stated that they were rear-ended, causing the defendant's vehicle to crash into a ditch. Defendant then approached them to check on their welfare, and once he saw they were unharmed, the defendant fled the scene on foot. The officer observed significant rear-end damage to the complainant's vehicle. The complainant provided a description of the defendant, and the officer ran the license plate and found the registered owners were Michael Lundy and Dylan Lundy. On March 13th, 2025, the officer received a call from Dylan Lundy, who wished to provide a voluntary statement regarding the incident. The defendant admitted to crashing into the complainant's vehicle and to fleeing on foot because he believed he had an open warrant for failure to appear for a window tint violation. The complainant positively identified the defendant by photograph. The estimated cost to repair was over $200 as the complainant believed their vehicle was totaled.
Okay. Can you run his license, please? And does he
Yes.
have any open cases anywhere? You can run an NCIC.
His driver's license is eligible, and I normally don't take note of Class C violations, but I do.
No, I don't care about Class C.
Right.
Didn't,
Um,
no, I don't care.
He does not have any open
Nope.
cases
Okay.
at the moment.
Got it. All right, Mr. Lundy, I'm going to find there's sufficient probable cause to go forward with the case. The only condition I'm placing on you now is you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you may not drive. You understand?
Yes, sir.
Okay, I will waive your appearance because you have a lawyer. Just stay in contact with Will. He'll tell you if and when you have to come back to court. I'll have you sign a receipt, Victoria. We'll have you take a seat while we get your conditions. You'll sign it and then you'll be free to go.
Thank you, Judge.
Don't pick up any new cases.
Yes, sir.
Is that pre-trial bond condition?
State's conditions.
Okay.
Okay,
Next is
so-
on page 12. Howard, come on up.
Can you file those, please?
Good morning, Your Honor.
Hi, Colin, how are you, man?
I'm doing good, Judge. How are you?
Good. What was the last name?
Howard,
Okay,
page 12.
there we go. Right. Good morning, Ms. Howard. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
On March 16th, 2025, an officer observed a vehicle driving the wrong way on Durham Drive in Harris County, Texas. The officer asked the defendant to step out of the vehicle. The officer observed the defendant to have bloodshot eyes and the moderate odor of alcohol emitting from her. The defendant stated she was coming from Clutch Bar and had one shot. The defendant stated her GPS told her to go the wrong way. SFSTs were conducted. 4 out of 6 clues were observed on the HGN. 3 out of 8 clues observed on the walk and turn, and 1 out of 4 clues observed on the one-leg stand. The DIC was read, and the defendant consented to providing a breath sample. The results were .119 and .123.
Okay, Ms. Howard, I'm going to find that there's sufficient probable cause to go forward with your case. Do you mind running to see if she has any priority to be honest, please?
Yes, Judge.
And a license?
She does not, and her driver's license is eligible.
Okay. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You understand, ma'am? You have a lawyer, he'll help you out. Just stay out of trouble. Don't pick up any new cases. If your license does get suspended, you may not drive, and Con will keep you in the loop. For now, I'll have you sign a receipt with Victoria. We'll have you get your conditions with Felicia, and then you're free to go. Thanks, guys.
Thank you, Your Honor.
Have fun. Good to see you.
Good to see you too, Judge.
Page 16. Phillips, come on up.
Morning, Judge.
Hi. You say 16? Okay.
Phillips.
Good morning, Mr. Phillips.
Good morning, Your Honor.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
On March 12th, 2025, at approximately 9:25 a.m., an officer was conducting a stationary traffic enforcement on a public roadway of the 7,000th block of IH 610 southbound in Harris County, Texas. The officer observed a red Ford pickup truck traveling at a high rate of speed with heavy traffic and the posted limit was 60 miles per hour. The officer witnessed the pickup truck bypassing other motor vehicles, weaving in and out of traffic at high speeds and coming dangerously close to other motor vehicles, with other drivers having to brake to avoid collisions as the Ford cut in front of them recklessly. The officer witnessed the pickup make multiple unsafe lane changes. A traffic stop was initiated. The officer reached speeds up to 110 miles per hour to catch up with the truck, but the pickup continued to distance itself from the patrol vehicle. The officer made contact with the defendant, driver, and sole occupant. The defendant admitted, "I know I was driving like an idiot. I just got off work." The defendant acknowledged he was aware that he could have caused an accident and hurt someone.
Mr. Phillips, I'm going to find that there's sufficient probable cause to go forward with the case. If I find that you drive like this again, it's really not going to go well for you. Do you understand?
Yes, sir.
I will protect my street at all costs. If that means putting you in jail with a $500,000 bond, I'm going to do it in a second. Do you understand?
Yes, sir.
Anymore, I will also take your privilege to drive away from you as well. Can you look to see if he has a license?
Yes, his driver's license is eligible, Your Honor.
You are not allowed to drive unless you have valid liability insurance in your name, and that is also now a condition of your bond. No reckless driving, maniacally driving, donuts, street takeovers, anything of this nature. Do you understand?
Yes, Your Honor.
You will sign conditions to this, and after that, you'll be free to go. You have a lawyer, I will waive your appearance. Just keep my street safe, man. Every day we have people dying. It's not fair. Do you understand?
Yes, Your Honor.
Okay, come on.
Thank you, Judge.
Right this way. All right, Judge, next is page 1, Al Bardon. Come on up.
All right, house May 20th. And then it's numbers.
I can work with it. Stand right here in the middle. I'm the judge.
All right, go ahead and have some.
Yes, sir. Thank you.
You can call Flores up now if you want to sign conditions as well. Sign those. What page did you say?
Page 1, top of page 1.
You were Mr. Al-Bardon? Sir, you're charged with terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Thomas
On
Flores?
March 12, 2025, an officer responded to a weapons disturbance call at a residence in Katy, Harris County, Texas. Upon arrival, the officer met with the witness who stated the defendant, her brother, and the complainant, her sister, were inside the residence and were involved in a verbal disturbance. The witness believed the defendant walked upstairs to retrieve a firearm during the altercation, which caused her to walk out of the residence and call 911. The witness, the complainant, and the defendant were eating at the dinner table, and the defendant told the complainant that he will shoot the complainant and the complainant will need to leave the residence. The complainant stated that she lives at the residence with the defendant. The complainant stated the defendant got into a verbal altercation with their father, and the defendant stated that he was the man of the house. The defendant attempted to slap the complainant in her face, and the complainant moved her head back, causing her hijab to fall off her head. The defendant told the complainant he would grab a gun, hold her down, and shoot her. The defendant would see that the complainant would not be in the residence. The complainant stated she felt in fear when the defendant threatened to shoot her.
Mr. Al-Bardon, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case that identifies Ms. Lubna as a protected individual. Get to know this protective order, because if you do something to violate it, the state can and will file a violation of a protective order against you. And it's one of the worst cases that you can pick up. Do you understand? One of the things is this comes with a residential restriction that you're not allowed within 200 feet of the Park Fair Courthouse. Do you understand? If you go back to this place, it's not going to go well for you. Do you understand? How old are you, sir? How much? 33. Do you work?
No.
Do you have the ability to hire a lawyer? So what I'll do is I'll have you fill out an application for me. I need to know whether you can qualify for a court-appointed lawyer. Any allegation of alcohol or McKinsey? Any alcohol or any dope, anything like
No
that?
allegations of alcohol.
Okay. So for now, what I'm going to do is I'm also ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand? I'll provide you a lawyer today and we can talk about how we go forward, but just be careful. I don't want to have to put you in jail. Do you understand? Okay. Do you mind giving me an application? Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Do you have the rip done?
Yes, I did speak to the complainant.
So what do they want?
They did not ask for no contact. My position that there should at least be some sort of cooling off period after something like this, even though.
Are they okay with having contact? No.
Yes, they would be okay with having contact.
Where's he gonna go? Do they know?
Yeah, that's true.
Because he's not working. Where is he gonna go?
Right. And I spoke to both the witness and the complainant, and both of them would be okay with him going back to the room.
Okay, so let's get him a lawyer and then we'll figure it out. Okay. Definitely no weapons, you know?
Definitely no weapons. We'll talk about it.
Yeah, okay. Frederick, do you have an arraignment?
Good morning, Judge. I don't think I have an arraignment, but I do have.
Do you mind, please? Thanks. Hold on, I can't hear you.
Let me,
Give me a second.
Judge.
Okay. Are you ready?
For the next one?
Yeah.
Page 6, Bird.
Let me just blow through the arraignments, Frederick, and then I'll hit you up, okay? Please. I don't think there are many. Say something.
Hello, Judge. Can you hear me?
There we go. Okay.
All right, got it.
Thanks. I just need to make sure it's the speaker's on. Hi, Sylvia. Do you have an arraignment? No?
No,
Okay,
sir.
let me finish with this and then I'll hit you guys up.
Sure, absolutely. Good morning.
Bottom of page 6, Judge.
Good morning, Miss Burse.
Sorry, I lost my voice.
Burse, that's what's right?
Yes.
Okay, ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. Just hang tight and we'll, okay?
On March 13th, 2025, an officer responded to a criminal mischief call at a residence in Harris County, Texas. The officer made contact with the complainant and the witness who directed the officer to the scene. The complainant stated the defendant came to the location, broke his motor vehicle window, and recorded the incident on his phone for the officers to see. The complainant stated the defendant left the location in a black Kia that had the location on. The complainant stated the defendant was on Rust Creek Drive at an apartment. He could point to her apartment. The cost of the damage to the motor vehicle was approximately $500. The officer reviewed the video and observed the defendant striking the front passenger window, causing the window to shatter, then leaving the location. The officer observed a brick inside the motor vehicle with glass shards inside the front passenger seat, floorboard, and outside the motor vehicle. The complainant was positively identified by her Texas ID prior to driving to her location per GPS. The officers followed behind, and the complainant pointed at the apartment as the defendant was standing right outside of it. The officer made contact with the defendant, who was wearing the same outfit in the video, and the defendant admitted to breaking the complainant's window.
Got it. Do you have the rip done? I'm assuming this complainant doesn't want to have contact with her?
We have.
Not yet? Okay. Ms. Burse, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes, Your Honor.
I don't care what's going on in your life. Don't have any contact with this person. I'm also ordering you not to be in possession of your weapons as well.
Okay.
If I find that you're a danger to my community, it's not going to go well for you. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Are you sure?
Yes.
Do you want to apply for a court-appointed lawyer?
If I really don't need one, then no.
You need a lawyer.
Okay, then
You're facing 6 months in jail,
Then yes.
$2,000 fine, plus it could go on your record, and it's disastrous when it goes on your record.
Yes.
It's a good idea. Do you mind giving her an application? So I'm going to have you fill out the application. I'll have you take a seat in the jury box. So we'll get your bond conditions. Do not leave until you sign them. And then
Okay.
I'll have you talk to a lawyer here momentarily. So can you file no conflict, please?
Yeah.
Please. Did you say she also doesn't have a license?
I did
I
not.
thought I heard you say that.
No, I did not say that. She has a driver's license number. I can run it really quick.
Yeah, do you mind? Because one of the things is she was left in the Kia, right? So let's see if she has a license. If not, I'm not gonna let her drive.
We're almost done.
All right, Judge.
Her driver's
Next
license is on.
Okay, great.
is page 15, Miller. Come on up.
All right, good morning, Mr. Miller. Sir, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The complainant informed the officer that on November 9th, 2022, in Harris County, Texas, the defendant was sending the complainant harassing text messages to the complainant. The complainant and the defendant had been in an on and off relationship and had recently ended it. The defendant would call and text apologies that he would love her. The complainant stated eventually that the defendant started conveying messages that were angry in context. The complainant blocked him in response, and then she began receiving calls and texts from unknown numbers. The complainant even asked the defendant's mother to tell him to stop calling her. The complainant stated that the night that she received calls and that night she received calls and texts from the defendant with him threatening to call Child Protective Services. The complainant and the defendant were using an app and calling and text. The defendant was using an app and calling and texting from different phone numbers, and he sent multiple phone numbers and different text messages that are outlined in the officer's report.
Gary Phillips.
Are we talking like tons of text and stuff? How many are we
Yes, sir.
talking?
Tons of texts from different phone numbers after the complainant had repeatedly told him to stop.
Okay, I see. I'm looking at dozens and dozens. Okay. All right, Mr. Miller, I'm going to find there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person. I don't care what medium it is. I don't care if it's a smoke signal. I don't care if it's Snapchat, WhatsApp, social media. If I find that you do, I will revoke your bond and put you in jail. Do you understand? No means no. Just, you don't have children with this person. Move on. 10,000 other fish in the sea. It's not worth it sitting in a 6x9 because of one person, right? All right. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you have the ability to hire a lawyer?
Yes.
Okay, so what we'll do is we'll give you time to hire a lawyer. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right, please.
Judge, that state bond conditions?
Please.
Yes, sir.
No contact and no weapons.
All right, Judge, next is page 21, Runyon. Come
And
on
then,
up.
if you don't mind, Abigail, would you mind reaching out to the person to let them know that we've placed these bond conditions in the event that she starts getting anonymous,
Yes, Your Honor, we have been
to let you guys know?
in contact with her since the case has been
Great.
filed.
Good morning, Mr. Lanyon. Sir, you're charged with illegal dumping. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 23rd, 2025, a witness stated that he saw the defendant dump a sofa on the 22800 block of Bear Lake Lane on Tuesday, January 21st. The witness stated that he was cooking and looked out of his kitchen and saw a truck and the defendant come out to dump it. And the witness took a photo of the defendant's license plate and of the defendant. The witness told the defendant that you can't dump trash there, and the defendant looked up at the sofa he already dumped and left. The witness stated he was concerned the defendant was going to dump the sofa at a nearby location, so the witness drove to the main roadway near his house and observed the sofa had been dumped at a abandoned car wash located at 11440 FM 1960 in Huffman, Texas, which is not an approved dump site by the Texas Commission on Environmental Quality. The witness is positive that the sofa is the same brown sofa that the defendant dumped near his house previously.
But he didn't see it.
No, Your Honor, but he did it was the same sofa, and he did follow, and then at that point, the sofa was still on the side of the road. Yeah. The witness stated he was cooking, looked out his kitchen.
I know that he sees it. So he doesn't dump it that first time. He goes to a location, he's about to dump it, but he doesn't, he takes off.
So I would just request, this is not with us, this is with environmental. I would just request we hold off on PC ratings and the prosecutor in this third case.
Okay, I mean, I'm willing to hold it, but, you know.
I get it. I just want to make sure the prosecutor.
Mr. Runyon, just take a seat for me in the jury box, please.
All right, Judge, next is
An off-docket arraignment.
I got it.
Has it up there?
Yeah.
Dave, do you have the case number for Villasana?
No, I do
You
not.
ready?
You ready?
Yes.
2549470. Villasana, come on up. Some cases.
I have, thank you.
Right here. Hands out your pockets.
Because there's such an activity number, because section is interpreted on as if you received any kind
You were Alan Villasana.
Sir?
Mr. Villasana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing?
Yeah, start on the theft because it's the earlier one here.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed the security tape from a JBL speaker box and placed other products inside a shopping cart. The complainant proceeded to keep the surveillance on the male and observed the defendant proceed to exit past all points of sale without any intent to pay the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance and attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. But both the defendant and the silver Chrysler were racing in competition side by side at points, with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing.
This is where the hearing takes a dramatic tone. The defendant isn't facing just one allegation. He's now dealing with both a theft case and an alleged highway racing incident. According to the allegations presented in court, officers described dangerous speeds, risky lane changes, and conduct that could have endangered countless drivers. Instead of simply setting another court date, Judge Fleischer imposes strict bond conditions designed to protect the public while the case moves through the justice system. Bond conditions like these aren't punishments. They are court orders meant to reduce future risk before a final judgment is reached. If you were the judge, would you have imposed even stricter conditions after hearing these allegations? Or do you think these restrictions are enough? As the docket continues, even more serious hearings remind everyone why accountability matters inside the courtroom. Microphone #VO3, final summary plus CTA round pushpin insert after the final hearing, end the transcript. This courtroom session demonstrates how one judge can handle a wide variety of criminal cases in a single docket while focusing on the same core principle, protecting the community. Throughout these hearings, Judge David Fleischer reviewed probable cause, explained defendants' rights, issued bond conditions, approved plea agreements, and repeatedly reminded defendants that future decisions would determine where their cases ultimately lead. Whether the allegations involved reckless driving, driving while intoxicated, terroristic threats, criminal mischief, theft, or illegal street racing, the message remained consistent. Every choice carries consequences, and the court expects accountability from everyone who appears before it. These proceedings also show how bond conditions are used to reduce risk while criminal cases continue through the legal process. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful Courtroom B.
I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive, and then you'll get with Felicia for your bond conditions.
If I come back, I don't have a right.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in public like 5 years. This is the first time I had a case since
Don't. Please.
Bottom side for your receipt, please. All right, as you know, it's before the Senate. Sorry,
Frederick, who you got, man?
Hello, Judge. Good morning.
Hey,
Hey, Judge, this is a felony pending case, and you brought me back because I guess the case is getting old. But on my last setting, I told you I was submitting a mitigation packet to the felony court, and you said I also got to submit it to the misdemeanor court as well. So essentially,
what are we talking about?
I'm sorry, his name is Smiley, Theory Smiley, I believe his name is.
Have you turned in the mitigation packet?
No, I was going to do, but well, I have it, but I just haven't turned it in yet. But what I wanted to clarify is, well, I want to turn into the felony first. I could basically do it the same day, I'm assuming. But this case is it? Do they just get a copy of the felony mitigation packet, or do I just target a mitigation packet towards this misdemeanor charge?
About a week ago, waiting for a response.
What do you want?
Me?
Yeah.
Basically, I'm trying to get him a PTI in felony court.
Have they offered that upstairs?
No, but they told me I could submit a mitigation packet. And they gave me a date.
All right.
Your case is 230 days old though, Frederick. So it's time to start getting, you know, like how soon are you getting it to where it's done?
It could be done today. I mean, I could submit it today. You know, I just wanted to
Are you
get
prepared to submit it today?
Well, honestly, I mean, I could, yeah, but I'll probably have to submit it by over the weekend. But I got all the stuff I need. It's not that difficult.
I don't want to. I'm not doing any more long research just because it's as old as it is. I mean, I'll set you up a couple weeks, like 2 weeks. Submit it as soon as you can, so that we can just try to get a response, huh?
Well, you have my word on that, Your Honor.
Okay.
Okay.
Give me a second. I'll get you there.
Sure.
You're welcome. Yes, Judge.
Bottom of page 23, submitting a mitigation packet, both here and in the felony case. He said by Monday, so like two and a half weeks.
Fair.
Howard?
You promise, right?
I promise, Judge. Yeah, it's not like I get higher from you.
Pinky swear.
There, pinky. There you go.
Two and a half. Good. I mean,
Okay, how's April 8th through the 10th?
April 8th to the 10th.
A Tuesday or Thursday.
That is
Victoria.
the 8th and the 10th is 8th is a Tuesday and the 10th is a Thursday. I'm assuming farther.
You can make the.
Or do you want the same day as a felony?
Well, that would be that would be preferable, I should say.
You want to do the same day as a felony?
Yes, because I can go finish that. At least you'll know I'll be there, so I have to check in with you to make sure everything's good.
Required appearance?
Yeah.
He's required today.
Your dude's not here today. He's supposed to be here.
You know what? I don't know that I informed him.
All right, I'm setting it for bond forfeiture. If he's not here next time.
There you go. I appreciate it.
Right.
I can do that. I can make up for that. You give me a chance.
Okay, man. We'll see you
Thank
soon.
You, I'll take that. All right, take it. Bye-bye.
Hi, Sylvia.
Good morning, Your Honor.
What you got?
I'm appearing on behalf of Mr. Guillermo Gonzalez.
What's the last name?
Gonzalez?
Gonzalez.
Gonzalez.
Okay, it's getting old. What would you want to do?
Judge, we submitted a mitigation packet on this case on March 11, and then they asked us to submit also the application because I think they changed the procedure. I was not aware of that. So I submitted the application and I'm waiting for them to make a decision on the request for the DWI.
What say you?
Sorry,
Do you have a response on Gonzalez as far as the PTI? Approved, unapproved?
This morning, I see. No, we do not have a response. We got everything in on the 17th. I got an update this morning.
So you just got it?
The application was sent on the 17th, yes.
Got it.
I just got we sent a follow-up this morning.
Don't worry about it. I mean, if you got it 3 days, that's just not enough time to look. I mean, we'll give you a week or so, you know? I'll set it off a week for them to take a look at it and see whether, it's yay or nay. Okay?
No problem, Your Honor. What day do you want me to be back in court?
You pick the day. I don't care.
Next
Whatever you
week? Can it be next Thursday?
Done.
Perfect. And do you want me to be present in court with my client or is his presence?
Yes, right. No more waived appearances after that.
Perfect, Your Honor. We'll be there on Thursday, the 27th. Thank you, sir. You have a wonderful
Okay.
day. May I be excused, sir?
Yes, ma'am. Thanks.
Thank you. Appreciate it. Thank you.
Some more time for the mitigation packet, but
Hi, Judge.
Good morning, Your Honor. May I approach? Please. How are you this morning? Good. I have an interesting situation, a little bit unfortunate, but it's not something that can't be fixed.
Okay.
There was a case in here, Michael Jones. I would give you the cause number, but I'll explain to you first, and then we can look him up. But Michael Jones pled to a Class A, but it was actually a Class B. All right.
So we can do a nunk.
Well, we thought that we could. I mean, I'm not sure if that's an option or not.
I should so.
I'm hoping that it is.
You can do anything you want until someone says no, right?
Yeah, right. That's right. I don't think anybody's going to object. We're bringing it to you, so we're not objecting to it. And of course, it is the case that was handled by the Public Defender's Office. And
so you're for the state then?
yeah, absolutely, Your Honor. I'm
Sorry.
Senior counsel for the district attorneys.
I need to get the defense lawyer then. I thought that you were
Okay.
defense.
All right. I apologize for not introducing
It's
myself.
okay. Can I have the cost number? Do you mind?
I will give you the cause number. It's 255-4843.
Let's see.
01010.
Okay,
And so my position now is senior counsel in the district attorney's
okay.
office.
Let me get a hold of Ms. Strong real quick, and then I'll have her come down, and then we can talk and figure out how to.
We'll just coordinate it with their coordinator. Would you like me to?
It's up to, I mean, I've got her phone, and she's here every day.
Okay.
So let me see if she's here, and then that way, if you give me just a couple moments, I'll see if she can run down.
Great bow tie, by the
I
way.
case for her on docket, but I'm not, you know.
Do you have something here today?
I think so. I was one of the documents. It also might be-
She's really great about showing
Yeah,
up,
she's-
so,
We
she
all
has the
love that.
case. Yes.
All right, I'll stand down, Your Honor. Thank you.
Yeah, give me 5 minutes. Let me get a hold of her.
No problem.
And then, Judge,
Sorry? He's good for that.
Oh, I'm sorry, Your Honor.
hey, hold on, Errol. I'm gonna put you on speaker, okay?
Okay.
So I have Zoom available. She can pop in via Zoom, or would you rather do this in person, maybe like tomorrow?
No, whatever is most convenient. We just want to make sure that it's done, done right, whatever.
So,
What would happen is the new trial, if we did a new trial, granted, what would happen, it would revert the case back to original status, A and B or A and J.
we can't do a nunc
And then
because
we
a
do
nunc
another-
is a clerk error.
That's what, yes. And so, a new trial, fine, and then we can, change whatever, I don't know. if
So, yeah, so let's do a motion for new trial. I can grant it. And then, I mean, do we have to do the plea all over again where we bring
Yeah.
him in?
We have to do the plea all over again. I don't know the status, but believe me, it's not gonna be a problem. You know what I
Case
mean?
credit now, we did 39 for
I don't think the time is a problem. Is it might be getting a hold of him. That's the issue because
He got released yesterday.
I know, but trying to get a hold of
I'm
him.
not gonna let it sit on your docket.
Okay, got it.
If you read behind.
I got it. Okay, I'll grant the new trial. Do you want to file it?
All right, that's fine.
Do you want to file it and then I can grant it?
I don't, can I follow it as a
And that's
state?
what I just have to do it, or we have to do it. I'm fine with doing it. Yes, I just didn't know it. Are we allowed to?
I don't know. I don't know who files it.
I'll look into that. If the defense isn't going to do it, we're certainly going to.
Okay, so Ms. Strong,
Yes,
I think that you might need to file the motion for a new trial.
okay,
I'll grant it. It reopens the
Okay.
case as if it opens anew. And I think that at that point, they're probably gonna end up just kicking it. And then we're all said and
Dismissing
done. Yeah,
okay.
to undo the
I'll
mistake.
file that today.
Cool. Okay. Done.
Thank you, Judge. And then Judge Fleischer, did you need me to come in person tomorrow?
No. Just, I'll text you the cause number so that you have
Oh,
it.
wait, once breaking up.
I'll
So yeah,
text
I'll
you.
file the motion for new trial. And then what else do I need to do after I file the motion for new trial?
That's it. Just let us know you filed it so we can put it in the queue and I'll sign it and I'll grant it. And that's it.
Thank you, Judge
And then we'll
Fleischer.
let
It'll be
you
in
know,
the queue.
and I can email you to let you know that it's all said and done. But thank you for bringing it
Perfect.
to our
It'll be
attention.
in your queue, by noon.
Okay. Well, no, Ms.
I
Strong,
appreciate,
take your
thank you for
time.
calling me, Judge.
Really.
And also, okay, I'm so sorry. Okay, so I
Look,
saw
look,
that
look.
there's-
But let's not, don't worry about it. Everything's good.
Okay.
Don't worry about it, Ms. Strong. You're doing great. Okay?
Thank you, Judge.
Thanks.
Okay,
Okay.
I'll file it. Thank
Bye.
you. Bye.
Okay. Thanks. Take care.
Thank you. Yes.
Judge number 2.
Judge, how are you?
Hey. Are you ready?
May we approach you?
Please.
Thank you.
Good morning.
Morning, Judge. I have a gentleman by the name of Kayuba Thomas who is with us today. He has a warrant. It's kind of questionable, but nonetheless, he does. And he wanted to turn himself in.
Okay.
I wanted to see if depending on probable cause, if you did set a bond, whether you might consider a PR bond because his medical condition.
Don't worry about it.
Gotcha. Would you like him brought up, Judge?
Please.
Okay. Mr. Thomas?
Yeah. Judge Powell, do you have the cause number by chance?
I think Abigail has it.
I do have it, yes, Your Honor.
What is
Ready?
it? Yeah.
It is 2555058.
Did you get it?
Yes, no problem.
Yes, Mr. Thomas. Coming up, Mr. Thomas. Good morning, sir. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
On February 6, 2025, the officers interviewed the complainant, who stated that on January 18th, 2025, the defendant came into the 5-minute oil change located at 747 Gary Ashford Road in Harris County, Texas, to have maintenance performed on his vehicle. The defendant let the complainant perform a cabin check on his vehicle, so the complainant got inside the vehicle. The complainant and the defendant then exchanged a verbal exchange because the defendant was upset that the complainant was inside the vehicle. The complainant's manager interviewed and attempted to de-escalate the situation, and the defendant told the complainant's manager, "I'm going to come back here. You better correct him before I come back here. I'm going to come back here and I'm going to finish him off with a gun. I will fucking come shoot you all. I will do a drive-by." The complainant confronted the defendant and told him that he was not welcome back. The next day, the defendant was captured on surveillance footage at the location speaking with the complainant's coworker, who informed the defendant that the complainant was not at the location. The defendant went into his armrest and the witness stated that the defendant went into his armrest and he pulled out his gun while uttering the words, "Because of what happened yesterday, I should have shot his ass," referring to the complainant. The defendant stated, "I'm going to come every day until I see him."
And Judge, that's simply not true. In fact, I have this.
Remember, this is a probable cause.
I
To
understand.
start getting into more stuff, I mean, my only concern is, was there a terroristic threat, right?
Exactly.
And I don't know, it looks like there were potential multiple threats. So which one is in the charging instrument? Is
I think the one alleged to have occurred
on the actual day in question when everything?
I can look and
Yeah.
double check.
Because what I have, Judge, is just a receipt from when he paid. And because of the way he was treated, they gave him a $20 discount. It shows on the receipt as well. So, you know, he had told them, "Don't upsell me, don't upsell me." He comes around the corner and the guy's in his car. So that's why they gave him the discount on the receipt.
But I mean,
Even so, Your Honor, a discount was a discount what happened.
No, I understand.
And just to clarify, it is the first threat on
first
January
threat.
18th.
Yeah, I mean, it's.
It is what it is. I understand.
So, Mr. Thomas, I'm going to find that there's sufficient probable cause to go forward with the case. The only thing I'm going to ask you to do is don't have contact with the complaining witness, don't be in possession of weapons, and don't go back to the 5-minute.
5-minute oil change.
Yes, sir.
The 5-minute oil change. That's all I'm asking you to do. Really? Just don't have weapons and don't go back, okay? That's it. As long as you can.
Also ask for no contact with the complainant because they don't.
Of course.
Already. Anything further, Judge?
No, we have to do bond.
Oh, I'm sorry.
When bring me out of PSM? Sorry.
It's already set at $100.
Oh, it is? Okay, so I don't need to. All right.
Yes, sorry.
So, Mr. Thomas, I'm going to grant you a PR bond today. You have a bond set at $100. I'm going to grant you a PR bond. All I'm asking you to do is just don't pick up any new cases. Just be nice. It's not hard. You've got a great lawyer here. Listen to him. He'll take care of you. I'll waive your appearance because you have a lawyer. You don't even have to come back. Just stay out of trouble and just, that's it.
Okay, thank you very much, Judge.
So I don't let him, I need you to sign a bunch of paperwork. We have bond conditions that we're going to create. I need you to sign them. Do not leave until you sign our bond conditions. You'll have to meet with police for your PR bond. And after that, you'll be free to go. Okay? All right.
All right, thank you very much, Judge.
And then, Judge Powell, do you?
Yes, sir.
Attorney of record, please.
Yes, sir, certainly.
Have him over there in the tower.
Okay, thank you.
Judge, I need the cost number.
2555 058.
058.
Yeah. Marcos, you ready?
Yes, Judge, ready for a plea?
Yeah,
Mr. Salvador, may I bring my client?
please.
Salvador?
Buenos días. Nosotros hacemos adversos con una plática.
Good morning, Mr. Salvador Mejia. Sir, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you have done. You need to understand that this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. This is important because if you get pulled over in a car, an officer comes up to your window, they see that you have a prior DWI and they smell alcohol on you or they smell anything funky, it's probably not going to go well for you. What we're doing today, the proverbial slap on the wrist, will not happen again. From now on, it's a minimum of 90 days in jail. Do you understand?
Yes, sir.
You're giving up the right to trial. Tell witnesses to testify on your behalf. Confront and cross-examine the accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, you can never change this. Do you understand?
Yes, sir.
You still want to do this?
Yes.
Is it true or untrue that you had a
no es verdad
5 or above?
tenía un 1.5 más? ¿Verdad o no verdad? ¿Verdad o no verdad?
Sí. ¿Verdad o no verdad?
True.
Answer. All right, sir, I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I am going to suspend your license for 90 days.
Yes.
Do not drive until you get a license. And I'm going to tell you now, I will waive the $4,500 surcharge that normally applies in this type of case because we all make mistakes. But if you continue to make mistakes where you endanger other people's lives, a second DWI, not only is a minimum of 90 days, but it's a $6,000 surcharge. Do you understand?
Yes, sir.
All right, good luck.
Thank you, Judge. Have excuse.
Thank you.
Good morning, Your Honor. How are you?
Right now, how are you?
Yes, Judge. Yes, Judge. Yes, Judge.
Who you got?
Approaching on Joe Brandon, Your Honor. Mr. Brandon, his appearance was waived, but wanted to discuss bond conditions with you.
The new driving.
No, Judge. Actually, no. You made it clear on that one why you had.
I don't even remember, but tell me, what do you want?
There's a reckless driving, but there's other things going on. You also put him on a monitor with a curfew. It has been over 3 months since this allegedly occurred on December 15th. We are not arguing the no driving part of this. We understand why the court's doing that. But with regard to the curfew and the monitor, we'd ask that the court consider removal. Well, I mean, if we take away so he can work.
Does he work in the middle of the night? Does he work in the middle of the night?
Judge, his his proposed shift that he's trying to get is going to carry over into the night hours. I mean, I would ask for amendment of the curfew, but if we get rid of the curfew, there's no point to having the monitor.
So let me know if he does get that. Come back and we'll talk, and I'm happy to amend.
Okay.
You know, he's been doing good, I'm assuming.
Yeah.
Okay. Yeah, I'm happy to work with you for it. You know, if he does do it.
Do we understand the no driving? I'm not going to ask you about that
It's
again.
okay, but if he does get it and he needs those work hours, I'm happy to do it.
Judge,
Yeah,
appreciate
okay, for sure. Counsel.
Good morning, Your Honor.
Hi, good morning.
Rivera Mendoza. There were some issues with his machine, Your Honor.
Come up, Mr. Rivera Mendoza.
Sorry, Your Honor, I think one of the interpreter. Mr. Rivera speaks English, Your Honor. He just.
So the first thing I'm gonna do is I'm going to send him for a drug and alcohol test right now.
Okay, Your Honor.
To send him for a test to see what, if anything, he's gonna test positive for. We'll have him come back and then we can deal with the bond violation.
Correct, Your Honor. Yes.
Yeah.
Yes, Judge.
I'm sending Mr. Rivera Mendoza for a test, please.
Yes, Judge.
Does he go back to the box, Your Honor?
He should only need to sign conditions.
Thank you very much, Your Honor.
But he has to come back. He has to come back. Okay. Yeah.
I just cut out. He has a scram. Do you need to sign anything to remove that?
No, once they see the order has been done, he just needs to go to, I thought the 7th floor? No. Ask Felicia, she'll know more.
Okay, thank you.
But once the order entered and they see it, at that point, though, he can go. I just don't know where. Hey, JP, ready?
I've got Mr. Good morning, Judge. I've got Mr. Disaki.
Okay.
Last name D-I-S-S-A-K.
Yeah.
You were rolling him day to day. He submitted all of his information for mitigation. We submitted it to the DA. They're reviewing it for a possible DWI, PTI.
Someone different that we were doing that with.
Oh, okay.
This wasn't someone else. This is someone different. This is just his case is old.
Oh, it's old.
It's not the one that you're thinking about.
Okay, maybe I'm eyes crossed. But
Is everything in?
We got the application yesterday, so I'm gonna get it turned in by the end of the week if I can. We just got.
Is he giving you everything that you need?
He's giving me amount of mitigation, like in record time, in 2 days.
Okay.
He gave me everything.
So you just need time.
I just need to get it in.
When do you want?
Can I resend them next week? I should have it in
Yes,
and
I'm okay.
give you an update, Judge.
That'll be turned in by then.
I will, Judge.
Okay.
It's on me at this point. Can I waive my client's appearance? And I'll just give you an update on, thank you, Judge.
Sure. Oh, I'm sorry. I didn't even see. Please.
I'm approaching on laws.
Okay.
It's the last name. He's on bond. He has a BVR, but can we hear PC on this one?
Sure.
All right.
You don't think there's PC?
Laws. Yes.
You don't think there's PC?
I don't, looking at the DIMS, but reasonable minds can disagree, Judge.
Have we done PC on this before?
I don't know. This is an older case and I just got appointed on it last month. So.
Did you already approach on PC on this?
I have not.
Don't worry about it.
I'll just be honest, Judge. I had assumed because of the age of the case that PC had been done. But.
Of course it has been.
Right.
But there's a new set of eyes, you know? Okay, ready?
Yes, Your Honor. Sorry, just reading through it's 2021 case. Thanks, sir. Look. All right. On October 5th, 2021, the officers were dispatched to a DWI call. Excuse me. Okay. Officer were dispatched to a possible intoxicated driver call. The witness stated he observed the defendant to go in and out of lanes as well as making a turn on the highway, hit traffic. The officers conducted a traffic stop. The officer observed the defendant to have glassy eyes, slurred speech, odor of alcoholic beverage, and poor balance, and a quarter full of quiet, please. Cold beer inside the vehicle. The FMSTs were conducted. It was a 6 out of 6 on the HEN, a 7 out of 8 on the walk and turn, and a 4 out of 4 on like stand. The breath is a 0.15.
So according to the DIMS, which is the sworn statement that we use for PC, it just says the officers initiated a traffic stop on the defendant's vehicle at an address, and there's no reason given in the DIMS for the stop.
She read something different.
That was not in the DIMS.
That seems to be from the offense report.
Sure, but I mean, what's...
But I thought for PC, we just used the DIMS because that was sworn to, and not getting into the.
Show me where it says that. I don't know of any rule that says that it's PC has to be done on just the DIMS.
Okay.
You know, I don't. If you can direct me to something,
Okay,
but I've
and
never.
that just may be my misunderstanding of a
Yeah,
policy.
I don't. And I've heard this before.
Okay.
Right, but I can't. I've never seen anything where someone has ever directed me to saying, "Hey, PC is only has to be just on the DIMS." You
Because
know,
the DIMS is sworn, and just like when Judge Powell was up here and he wanted to get into the facts, he couldn't.
I mean, if he's getting into the facts, then that's something different, right?
Well, and getting into.
That's a sworn document too.
The office report's on a sworn document.
Thank you very much. I mean, I guess, Your Honor, my thing is it's a public record that they're using them taking the offense report. And also, I have never seen it before where we have to rely solely on the damage to the public law since it's probably law. In fact, when we go to the grand jury, that's all offense report, that's all den, it's everything that comes in, it's even evidence. That's probable cause.
Yeah, I don't know. I don't think that. I mean, let's look, because I don't know, you know?
Okay. I'll put it down.
I'll
Go check with.
Sure.
Ms. Rogers.
Hey, you ready? Come on.
Yeah, I just want to approach on bond conditions for Mr. Bardan.
Okay.
BARDAN.
Oh, so you got appointed Mr. Albardan?
Yeah.
Great. Okay.
He has a residency restriction to stay away from his father's house. That's where him and his siblings live. And I want to approach you about lifting that up to no harmful or offensive contact.
And I'm okay. So he's Mr. Albardan. Come on up. Your lawyer wants me to change the conditions so that you can go back to the house. But I want you to understand that if you have a very tumultuous relationship with these people where you're always butting heads with them, it's not going to go well. I don't want you to have any threatening or harassing contact with them. What is threatening or harassing doesn't matter what you think. It is what they perceive. So if you go like this, is that threatening or harassing? It most certainly is. And it can land you back in jail. Do you understand? So if you cannot be nice and if you cannot get along with brother and sister or dad, be very careful. Because if I get wind that it's not going well and that you're threatening or you're putting anyone in danger or you have a weapon, I will put you in custody. You understand? Okay. All right. I'm done.
Thank you, Judge. I'm excused.
The only, Mr. Albardan, the only thing I'm taking off of the protective order is the residential restriction. Everything else in the protective order stays. So if you threaten them, if you harass them, they can charge a new case on you. Do you understand?
Yes, ma'am.
Okay. All right.
I will convey that.
And if you can file, no, now we need,
State bond condition.
yeah. So, Mr. Reedy, we need new bond conditions. He can't leave just yet, so we need him to sign no threatening or harassing.
Right there, not to leave.
Okay. Stacy.
Hey, Herbert.
Okay.
How are you, Judge?
What's new, man?
Same old.
You can pick a day?
Well, I have Monday and Tuesday are not good for me. Wednesday or Friday of next week is fine. I mean, I have a few days every week.
All come together with a meeting of the minds?
I think it's from what it sounds like, our officers we need two officers. One is.
One, yes. One is unavailable on Wednesday and the other officer is unavailable on Thursday and Friday. I've reached
So
out.
go into the next week.
Yes, yeah, okay.
I don't care.
Both of them should find out their availability for next week. I'm just waiting to hear back. The next week after that.
Okay.
Yeah.
Okay.
No stress, man. We have enough drama. Just pick a day. I don't care.
I'm not
Just
looking
make
for
sure that, like, I don't want to keep doing this stuff. This is like,
That's
this is the
why
last time.
Before we said, hey, go next week.
If we set this for the next hearing and one of the officers comes back and says, I'm sorry, I can't do it. I don't give, we're going forward without that.
Yes.
All right?
All right.
Whatever you want.
All right.
Of course.
So that information you were telling me about for the VPO?
Not quite, we need it.
Cheryl Diggs was the magistrate that signed the original bond conditions.
Right, but this is,
Would you like us to amend it?
no, it's not you, it's them.
Yeah.
So let me, I'll bring it up to them in a second.
Okay.
Ralph.
Oh, yes, sir.
Hey.
I've got Mr. Basie and the state would like to evaluate it. It's an old case, Your Honor, but they asked if we could reset it, which I'm in agreement.
This is an interesting one.
Right, it really is.
A week. We filed for a week.
Yeah, sure, yes.
Do you have an offer on the case?
Just want to do one, just the,
Yeah.
I just want to do one little case law.
Not a problem.
thing I think.
Is discovery complete?
Discovery complete.
All right, you've got an offer?
I think we're gonna be able to resolve this case.
Okay, so I guess set it for next week. And then we'll come back and,
Want to be more of a case law.
no problem.
Sure, thank you both.
Hi, Ralph.
Thank you.
Judge, for El Bardon, their state's conditions, correct? Oh, no. I know, I heard say it's your, they're not.
Hey, Anna, come on. So you're saying that it doesn't, the DIMS has no reason for the stop, right? Is that what
Yes.
you're saying?
The sworn statement, and speaking with Ms. Rogers, we're looking, but it's not,
And I'm looking to.
okay.
I am too.
There was a class action lawsuit, and as part of the settlement, the agreement was that Harris County would use the DIMS to support
Okay,
PC, but we're getting that all together.
me too.
Okay.
For the 26th, March 26th. Want to call him up and sign? Yeah, you check, he's out there somewhere.
You said pursuant to the consent decree, is that what you said?
There's a class action lawsuit, it's Lomas and Elgin versus Harris County and.
Okay, hold on.
Southern District of Texas. Okay, go ahead and sign, please.
What, okay, what is it?
Corey Millen? Yeah.
All right, there you go. You're good to go. You're welcome.
Was there a result for that?
Yes.
Or is it in action now?
No, this was some time ago. So this was before the DIMS summaries had an oath or affirmation at the bottom of it. So there was a class action lawsuit brought by the Civil Rights Court. And out of that lawsuit, it was just allegations of Fourth Amendment violations, because when a warrantless arrest occurs, the Fourth Amendment requires that a neutral magistrate make a finding of probable cause supported by oath or affirmation. So as a result of that lawsuit, Harris County settled and said, okay, we're not going to concede that we were violating the Fourth Amendment, but we will now include an oath or affirmation. So I think it is a Fourth Amendment issue.
I'm curious, so I'm curious, for PC purposes, can state use an offense report to supplement a DIMS? Or are we strictly going in the four corners of the DIMS and nothing else? I don't know.
Well, the four corners of the DIMS is what's sworn to. The offense report is not sworn.
I find that really weird. How is it that they're creating an offense report and they don't swear to it? You know, because there's, in the offense report, you also have a search warrant. Like 9 times out of 10, you've got a blood search warrant, and that's sworn to.
That, Your Honor, if the officer makes something up into the office report, he is committed a crime. So I mean, I don't say that the office report is not sworn to. It's a government record that this officer is putting his name on. If he makes something up or if he lies about something, that is a crime.
Right, but filing a false government document is a different crime than perjury.
I get it, but
Wouldn't that be filing a false,
Right, but perjury's
an official document?
a different crime.
No, but it would also under the purview of filing a false,
Well, Judge, if an officer came into court and was asking for you to sign a search warrant, and they just gave you their offense report, that would not be enough for their search warrant. And it's kind of the same idea. Because this is a warrantless arrest, there has to be someone swearing to the facts to support probable cause for that arrest. And similarly, with the search warrant, it has to be supported by oath or affirmation. This wasn't a warranted arrest. It was a warrantless arrest. And so it must be supported by probable cause. That includes an affidavit.
Was there blood in this case? Okay, give me 5 minutes.
Okay.
Huh? Okay.
If it's okay with you, we'll take.
Can you show them?
Yeah, that's fine.
I'm done with everything, I just, because you missed it. Yeah.
Hey.
Last name is Bledsoe.
Bledsoe?
Bledsoe.
Okay, you want to bring him on? Are we going on the evading and the terroristic threat? It's going to be dismissed. Good morning, Mr. Bledsoe. You were charged with evading arrest and detention. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement where they're going to dismiss your terroristic threat in exchange for your plea on the evading arrest. You need to understand that the evading is an enhanceable offense. This is going on your record today. It'll be there forever. From now on, if you ever run from the cops again, you'll be facing a felony charge, years instead of days. Do you understand?
Yes, sir.
Not only that, it's a minimum now of 90 days for any new cases that you pick up in here. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays on your record forever. Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, sir? Guilty or not guilty?
Yes, sir.
I'm going to find you guilty. I'll sentence you to the agreement. If it's enhanced, it'll be abandoned. Good luck, sir.
Thank you, Judge.
Anna.
I'm ready with Mr. Gladstone.
Anna, you ready?
Yes, Judge.
Mr. Laws, come up.
Because you're gonna head down to the first board of elections, and then we have this room, to be here for today. So, please go down there, so we can help you get there.
We have court orders for a reason. And when you don't follow court orders, bad things happen. Do you understand? Yes. You were ordered to get an interlock and you didn't get it, or a portable device, and you didn't get it. That's unacceptable. When you don't, there are serious, serious consequences. The only thing I'm asking you to do, don't endanger my streets. Don't kill someone on the road. Do you understand?
Yes, sir.
I'm going to find no probable cause in your case now. But if you come back with a new case and you don't follow court orders, it's really not going to go well for you. Do you understand?
Yes, sir.
All right. Good luck.
Thank you, Judge.
I think that we are, you know,
Sorry.
it's okay. No, and I think you're right. You know, we were going through the lawsuit and, 2017, the county came into an agreement where we're basically holding it to a higher standard, so to speak. I mean, theoretically, could I weasel out of it? Yes, but I don't want to. I want to stick with the agreement that the county came to with the district attorney's office,
So, I'm not saying this, I'm just for curiosity.
The DIMS has to state an offense, right? It has to have all the elements of the offense to go forward. The reason, I would presume that offense reports don't is because they're continually just updated and they're amended and they supplement it. So it would be unreasonable to have an officer every single time they swear to over and over and over and over, because shit, you might get like 15 supplements.
Here's my question for the board, and I'm not saying we do this in this case, I'm just saying for cases going forward.
to me then, does that then behoove, let's say we can't take it to grand jury? I mean,
You can, of course you can.
So.
Just because I find no probable cause on something, if you want to go indict it, go do it.
Right, okay.
Absolutely. There's nothing barring you from doing that, right? Because if a grand jury finds something different, then that's on them.
Yeah.
As far as me, I'm going to just hold to the standard that we agreed with the county in the lawsuit.
Yeah, I'm just, and this is for my own.
And look, you're not going to hurt my feelings if you go to a grand jury. I don't care.
I know you did.
Oh, really?
I just, so we wouldn't be held to that same standard.
You need to do what you think is right.
Okay.
Like I'm going to do it, and like she's doing it. The problem is that whoever had the apps, they didn't dive into it and really look into it as Anna did. You know, not everybody is.
This is required to be.
Which is good.
Thank you.
God love you. All right. Hi, Shreya.
Hi, Judge.
Oh.
I'm Miss Lovey.
Okay.
So I wanted to address the BDR.
Where is Miss Lovey?
It's right there.
Come up, ma'am. So here's, Shreya, here's what we're going to do. I'm going to send her for a drug and alcohol test now.
We already did. She came back negative, Judge.
Oh, great. Good job. But if you miss again, it's not going to go well.
So
It is your responsibility to let Shreya know if you're going out of town, if you have some other obligation, because we can always work something out. But I'm not going to continue to do this. If you miss again, it's just not going to go well for you.
So Judge, that's what we want to talk about. So when I was first appointed to her, Ms. Lovey talked to me about her work schedule. And I said, look, let's just wait and see what happens with the UAs. If you get called in for a UA, but you have work, I don't want you to lose your job. I told her that. Yes. So
They give you a sufficient amount of time to come.
same day.
Yeah, there's 6 hours.
Yes. So she's a behavioral technician at Action Behavior Center.
Yes.
And she cannot take off work.
They penalize me.
So, and do you want to talk to the judge about that?
Yes. I bought some printouts as well on my works attendance policy. So we have like a 2 weeks ahead of time type thing. They'll let me off. I had to beg and say it was like a life emergency just to get Thursday. I also have asked before because I remember the original court date was for Tuesday, the 18th, I believe. And 2 weeks ahead of time, that court date, I wasn't scheduled to appear. And I said, since I missed that UA, would it help for me to appear in court that day, even though I'm not required to come, to show that I'm okay with appearing to test? Testing is not something I'm trying to avoid or anything, but if I can put, time and effort into make my appearances, be here, and also keep my job security, is there a way that we can balance those two things? Because I have no problem showing up in testing or anything like that. I also live in Humble, Texas. So traffic times, I get off work anywhere between 4:30 and 5:30 every day. And I did bring some printouts just in case that's needed of our policies and everything.
I'm not going to take off the fact that you're not supposed to use alcohol or drugs.
Right. Absolutely. But is there a way we can schedule her testing? Even if you want her
And that defeats the whole purpose of it being random. You know?
I know.
Because that's how we catch people. If you know when the test is going to be, it defeats the purpose of it being random. So why do we do this? Why don't we just work something? If you get called on again, call Shreya, and then Shreya can come to me, and then we can work something out somehow. You know?
Okay, and every single time I will need your work schedule.
Yes, and I have printouts
So
from the
just
missed date as
send it
well.
called on, let Shreya know. Shreya can come to me, and we can try to work something.
Okay.
Okay? Because I don't know, you may not get called again. I don't know. You probably will because you missed now, right? But just if and when they do call you, let Shreya know and we'll try to work something out. Okay? Okay. Good luck. Yes, ma'am.
And then we'll just get a reset on this.
Let's get a reset. And your appearances, no reason for you to come, unless, of course, there's a.
So, and I say that, but your appearance was waived, but then when you have the UA, because you can't go to court, then you're gonna have to show.
Okay, yeah.
Okay. Good luck.
Thank you.
Have a seat. That's my sweater.
Yeah, the computer might have.
Okay, thank you.
Yesterday for the SB7, the entire county, we have PR bond dismissing or disposing of it.
Okay.
So they weren't able to release them yesterday because the sheriffs never created the secondary out of county.
Oh, right. So they're gonna do that now.
We're gonna do that. I just need you to write on here 1,000 or however, whatever bond you want to set so we can do the PR bond.
Okay, I'll just put different statement down.
What was the other, was this the robbery?
Yes, this is the robbery that never got generated as.
So 30,000 on the robbery?
Okay.
And then, okay. Ready? Yeah.
Your Honor, I'm here on an individual by the name of Suy, S-U-Y, Mejia.
Okay.
Your Honor, I haven't been able to get hold of him for the past month. He lives in San Antonio. I've called every number. His phone is
So
not.
I'll set it for bond forfeiture for Monday if you want to send a letter, to the last known address, and then that way you have a CYA. We can, or maybe like Tuesday, that way gives you enough time.
Tuesday would be.
Okay.
Thank
So
you.
SFBF Tuesday, okay? If he does not appear at that point, it gets revoked.
Yes.
Okay?
Maybe excuse.
Yes, ma'am. Thanks. Hey, Blaze, sorry, to disturb you. I got something else to show you too. This is a 2B. Look at the charging paragraphs.
Yes, I need to re-sign that one.
Yes.
And we'll shoot them out and sign them.
Yes, sir.
Hi. You ready?
Gallegos, he got out.
Come up, Mr. Gallegos.
Good morning.
Is it? All conditions will continue. You are not to use. Do you understand?
Yes, sir.
I will test you again in about 45 days. If you test positive again, it's not going to go well for you. I'm not asking much. Do you understand?
Yes, sir.
Okay. All right.
And
That's
we are
it.
doing, we're working on a PTI with the,
Quicker you get it done,
that's what I'm saying, with,
quicker it is for you.
they do want to test as well as a condition, so, once we test them again, then we get submitted.
You hold the keys to the jail cell. No one else. Do you understand?
Yes, Your Honor.
Thank you, Your Honor.
Yes, ma'am.
Thank you.
Can I get on the latest?
Judge, I have an off-docket, bond conditions, first appearance, he set for tomorrow, Friday, but I'll be in
You
Fort
do it
Bend.
today? Yeah, of
Yes,
course.
I asked my client.
Oh, yeah, I'm happy to do it.
I'm gonna see, because you may want to talk to him, I'm gonna see if.
Do you need is a bond already set or no?
The bond is set and.
What is it, a DBI?
Yeah.
Okay, yeah, I need him or her. So just let her know, and then when you're done, bring them.
Okay, thank you.
Yes, ma'am.
I don't. Oh, I thought it was. I just was interested at the bottom. Oh, okay.
Did you want 45 days?
No, 45, right?
Yeah.
44 or 5 does.
I know, this is one of the floor.
Yeah, no, probably, no. That's professional. I mean. He signed up and said, yeah. He was seen again by the keeping in that's on
I've heard back from the prosecutor. Or sorry, not case. Ron Williams was the legal dominant case.
Oh, yeah.
Said it was in the road, so.
I still don't know. I don't know that.
Come up, Mr. Runyon.
Yes, Your Honor.
I'm going to find that there's no probable cause to go forward in your case. Aren't our streets dirty enough?
Yes.
Don't say anything. Just please,
Understand.
keep it nice.
Yes, sir.
All right, please.
Lee.
Your Honor, just on news, because he didn't see the assault.
Yeah, no one,
Are we getting the dismissal?
That's gonna go through environmental. I've emailed her, so that's kind of.
Okay.
Hey, hi. Good morning.
You know, I was here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat, a serious bodily injury charge.
Hi, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was competent, but I still don't think something's right with him. I talked to him.
So get a second opinion. If you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Would just, for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
No, he communicate. Just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no, if we're going to do this, we got to do it now. We have to decide we're going to trial now.
That's I want to get out as quick as possible and then.
Kind of, but that was a little more than that though. Just
to talk to him?
I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but this just might be a misconception. Maybe jailhouse lawyer talk or not understanding his.
I don't know.
Cases.
Does he have his pending in the 220? This case?
No other cases pending as far as I know. Counsel, this is the only case that's not very good. Check 75 of them to do.
Thank you. Sure.
No evidence of any words or anything, probation, or felonies.
Let me just double check.
What is your cause number?
Oh, mine
Yeah.
is 5417.
Oh, I guess that's what you have. Okay. Harold, or he's already here. Okay, switch. Good morning, Mr. Flores. How are you?
Good today.
Good. The reason that you are still in custody is that we gave you a PR bond and you take off. You don't come back to court. This has not happened but once. It has happened already multiple times. So that's why I can't just continue to give you PR bonds. When you do, you just take off. The only thing I need you to understand is that, when you plead guilty to something, it sticks with you forever. You cannot try to plead guilty to something, get out and try to change it or do this or do that. This is when you do this, when you accept a plea bargain, it stays.
Judge, Your Honor, I'm truly sorry for what I've done, like my whole life. I just asked for another PR bond. I'll make it a court. I actually call my mom, see if I could stay with her until she drops me off at court, and whatever they say from there, you know, if I'm guilty or not guilty, I'll plead guilty. Or if I'm innocent, I'll
Where you
plead
living
innocent. My mom stays in Tomball now.
No. Are you living on the street? Where are you living?
I'm homeless, but I've actually talked to my mom, and me and her are actually going into a good relationship now.
Did you just get picked up?
Like mother and son. And yeah. You know, like they caught me at the airport, and
look, I don't want you to talk about the case. The thing is that I don't want to continue to give you someone a PR bond if you're just going to go to the streets. The streets are not a safe place.
I won't go back to the street. The streets aren't for me anymore, man. Like I don't want to be in the street. I don't want to be homeless anymore. And you know, I've talked to my mom. She's doing real good, and she actually wants me to be around, pay the bills, and you know, and own a house of my own. You know.
Let's do this. Why don't we do a TRAS to see how we go forward? Because I don't know, and we can have the clinicians evaluate them to see how we go forward.
First,
if you want to do an independent one, I'm happy to give you money for you to do it. Or like I would suggest is just do a TRAS to see where do we go? Because I don't know, you know, but you know, having clinicians talk to him might be the best way to go to see how we go forward. Because the problem is, Harold, is if we just throw him out to the streets, we're throwing him out to the wolves. You know, if he doesn't have a place to go to, we're just, you know. Whereas if we have him TRAS, we can try to get down to what the true issue is and why it keeps happening, and then we'll figure out a plan, you know. So you just let me know whatever you want to do. I'm happy to do it.
So just when we do the TRAS, we just set that up with the CLO or?
Yeah, so we'll have Shatori set it up and we'll do it. We can expedite it so it gets done within the next couple of days. So he's not just lingering.
Judge, has his competency results due then?
Yeah, competent. Yeah.
Burr?
So we can get it done. And then that'll really tell us, perhaps it needs to be in mental health court. I don't know. But that's what we can get the TRAS for.
So what do you think, there's 2 weeks or?
No, not even a week. A week. Okay. Thanks. All right, Mr. Flores. Okay, are you ready?
Thank you.
Yes, ma'am. Alipio, come on up.
Is this the off docket, Judge?
Yes. Do you need the cause number?
Yes, 1 second.
Because it's going to be with you.
Okay,
It's 2555472.
thank you.
Good morning, Mr. Alipio.
Yes.
Sir, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F-250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60 mile per hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between 2 lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank 1 alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HDN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch, white cup in the center console.
Alcohol while driving?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in the state will know to arrest you and put you in jail. Do you understand?
Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian in?
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because he owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio. Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes. Yes.
Because you have a lawyer, I will waive your appearance. That means that you don't have to waste your time coming to court. But it is your responsibility to stay in touch with Lee. If she tells me that she can't get a hold of you because you're ducking and dodging phone calls, you're playing games, you're not responding to her, likewise, I will issue a warrant for your arrest. I'm going to do everything in my power to protect my street at all costs. And I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria where we will have you sign a reset. After that, you'll get with Fleischer for your bond conditions. And after that, you'll be free to go. It's not forever, but I want to know that he truly appreciates and not just, oh, I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in a long time.
How do we know? How many times has he not been caught that we just don't know?
No.
I don't know, but all I know is he's got alcohol in the car. He has a prior DWI, so he's already on notice of what you can and can't do. I have a problem. So just proactivity goes a long way.
Yes, Your Honor.
All right, good luck to you, Michelle. Alipio.
No.
Counsel, you ready?
Yes, Judge. Judge, I have an arraignment tomorrow and I'm in Galveston.
That's okay.
Can I?
Yes, of course.
You ready? Talk about it now.
Hold on, did you tell Victoria?
I have not. I can.
Please, so that she knows as well. He's been here for a long time. Deshaun, you want to talk to me while we're waiting? Come on.
Mr. Rivas?
Okay. Mr. Rivas coming up?
How you doing today, Judge?
What's new, man?
Nothing much.
Friday Eve.
Exactly. Yes, sir. No, sir. To the judge? Yes, sir.
Good morning, Mr. Rivas. Good morning. Sir, you're charged with interference with the duties of a public servant. You're also charged with possession of marijuana ×2, right?
Yes, that's correct, Judge.
So I guess both of the weak cases are being dismissed in exchange for this.
Yes.
You need to understand, Mr. Rivas, that this case is going to go on your record. It will be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, it's going on your record. It'll be there forever. This is what you want to do.
Yes, sir.
I didn't plead to the offense. I'm going to find you guilty. I'll send you to it. I'll run your court costs so you won't owe anything. Good luck to you, sir.
Thanks, Judge. Have a good day.
Step over here.
Yes, Judge. And he's going to come in and sign the conditions tomorrow. I just wanted to talk to you about it beforehand so I could tell him what they're going to be.
Oh, okay. What's your cost?
It is.
So you're just not going to be here tomorrow?
Yes, sir. I'm going to
Just
be.
do PC tomorrow.
I'm going to be in Galveston and yeah, we'll wait PC.
Know that you can always Zoom.
I know, but it's always hard to do that.
Okay, not a problem. What's your cost?
255-5734.
On Garcia.
Yes, sir.
Got it.
And it's a .1213 breath test. He hit a police car that was blocking an accident scene as he pulled up. No one was in the car. It was blocking the scene. That's the situation.
You want to read it real quick? Oh, we're still going to do it tomorrow.
Oh, we're still doing it tomorrow.
Tomorrow, yeah, we're just kind of like informal PC.
Thank you.
No, never.
I have to leave or just, one have to leave it, but.
I can come after this.
Yeah, no problem. When are
Okay.
you ready?
Yeah, I'll be right there. Okay. You ready?
Oh, which one?
Oh, yes.
Yeah, go for it.
All right, got it.
So on March 15th, 2025, an officer was working a crash scene in Pasadena, Harris County, Texas. At approximately 1:15 a.m., the officer heard tires squeal and a vehicle collision a short distance away. The officer observed a vehicle had collided with a fully marked police vehicle with emergency lights activated. The officer observed the defendant to be the driver and sole occupant, and he appeared confused and had glossy eyes. The defendant exited the vehicle, and the officer observed red glossy eyes, slurred speech, uncoordinated and lethargic movement, and the odor of alcohol emitting from the defendant's person. The defendant admitted to drinking 2 beers. SFSTs were conducted 6 out of 6 on the HDN, 3 out of 8 on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read, and the defendant consented to the breath specimen. Results 0.134 and 0.123.
Any prior to be honest?
No, Judge. Well, sorry.
There's someone else's criminal history. There's no DWIs on it, but there's someone else, clearly someone else's criminal history attached to his out of California.
So that's incorrect. That's not his criminal history. is what
No,
you're
there's
saying?
no way it can,
Okay.
there's like, I can show it to you. It's about every other crime other than DWI is listed from 2017 all the way to now. He's never lived in California. His name is Cesar Garcia.
Yeah, there's gotta be a quintillion Cesar Garcias. But does it match up with the FBI number? I mean, because they always have an FBI number, you know?
I can show you the history if you want to see it, Judge, so you can see it's literally, like, he wouldn't be here. There's ag robberies, ag assaults, robberies, all of them.
I don't know. Do you see any prior DWIs?
No prior DWIs on the California history.
So, I mean, I guess do this, you know, if there's no prior DWIs, I'm not gonna put an interlock on it, right? I'm gonna order him no drugs, no alcohol, randoms, that's it. But look to see if it's him or not.
Right, absolutely. I've seen this happen before.
And of course we have to.
Yeah, so
It happens.
we'll look into it.
So, yeah.
Because of his age, it just didn't add up.
Oh, is he young?
He's 26 and his history goes back to
Hey,
27.
I've seen people here 19 with the laundry. So, yeah, you're good. So just pick a date and then we'll do PC again with him. Just no drugs, no alcohol, and randoms. That's it.
Thank you, Judge.
For sure. Did you need something, counsel? Oh, he's coming. We're waiting for him to come back.
Yeah, for the result.
Yeah, okay. I'm gonna.
Thank you.
So,
We'll get a. Keep going. Picture of
okay, let's do it.
Hey, James, what's that? Who is that?
Ms. McCoy. The results are back.
On Rivera.
Oh, if they weren't married, they wouldn't be unique property.
Did you get the results back, Felicia?
Yes, they're negative.
I am now amending your bond conditions to put an ankle monitor on you so I know that you're not consuming alcohol at any times. The next time you test positive and I don't give a rat's behind what it is, I will put you in jail. Do you understand? I don't know what your immigration status is, but if you're not in this country with proper permission and you go there, you will be stuck like Chuck in there until this thing is over. Do you understand? No means no. And from now on, no tolerance. Okay, thanks.
Thank you, Your Honor.
The current device stays. He will now also get an ankle monitor, Felicia. Right. Take a seat for me, sir.
Private citizen acting as well.
Right.
Hey, there's a
You guys happen to know who's the gentleman? Who's the gentleman back over there?
That's his client.
Yes, that's
April 5.
Wait till you hear his story. Wait. I don't want
It's
to.
always got great
Yeah, I
stuff.
don't want to present it.
Hi, Ricardo. Hey, Judge.
This is Miss McCoy.
Hello, sir. How are you?
So, Ms. McCoy, let's talk about something funny.
Okay.
Actually, it's not very funny, but it's actually quite sad. Your lawyer came to me, was it yesterday or was it the day before, asking for a PR bond?
Monday.
Asking me to give you a PR bond. Do you think that was a good idea? To give you a PR bond?
Are we looking at the history? Okay.
We've never, ever once appeared on your own here when we give you a PR bond. Every case that we have with you sits at around 10,004, 10,005, because you never appear. When you come to court, good things happen. Do you understand? If you ever need help, if you need a place to sleep, if you need food to eat, if you need a cell phone or tablet, anything you need, all you have to do is come and ask, and we will bend over backwards to help you in any way that we can. But when you continually fail to appear, you become a flight risk and we just can't trust you. So he came to me asking for this PR bond. I laughed because I know if I give you one, like little wings on a bird, bye, you just don't come. Next time, if you pick up a case, come and we'll help you with whatever you need. I don't care what it is, anything you want, I'll give you. You want treatment, you want help, anything. You now stand charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. You're giving up a lot of rights by entering into this agreement, Ms. McCoy. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. You know, you've spent the better part of the last 4 years in and out of custody for one thing or the other. Before you know it, 20 years will have passed and you will end up in such a bad place. You're going to look like the things that on the street that you'd never think that you would be if you continue at the rate that you are. You need a change before you really do some damage that you can't crawl out of. How do you plead to the criminal trespass? Guilty or not guilty? That's all right. You know what we're doing, right?
Do you want me to talk to her for a moment? I don't.
No.
Okay.
I mean, your plea, do you know what we're doing? We're doing a plea for guilty, right? Is this what you want to do?
Yes, sir.
All right. All right, ma'am, I'm going to find you guilty. I'm going to follow the agreement. Come back next time. All right, good luck. Thanks. Was it 13 days credit? 12. 12.
Mr. Proctor.
Okay.
He's not here.
Okay.
He's a bond. He has a surety bond. I called his bond company. I called his dad. I called him. Can we roll it till tomorrow?
Sure.
Okay.
Set BF tomorrow.
Okay, thank you.
No, sure, tomorrow.
I got you. Thanks.
Carter.
Hey, Judge, may I approach?
Yeah. So you got something interesting?
Oh, we were going over, on this case, we were talking about, if a private citizen, takes somebody's car key and seizes somebody and holds them there till the officers show up, is it, allowable or not? And so.
Well, it would have to be a felony or a breach of the peace, right?
Right. It would have to be one of those because otherwise it could, I was telling them it could be argued it's fruit of the poisonous tree. It's an unlawful seizure. And so if it's a government action,
I thought you were getting more toward a like kidnapping.
Oh, no. To like say it's an unlawful seizure, like, there's, we were comparing versus it's not because it's a private actor. But I'm saying, hey, even if it is a private actor, if it effectuates what a cop would be doing, it would fall under the same tenets of unlawful search and seizure. And so.
Certainly interesting.
Yeah. I don't think we're going to get there, though. I don't think we're going to get there on this one. I don't think we're going to get there on this one. It's
theory's wonderful, you know?
Makes it so fun.
So,
yeah,
Mr. Lázaro Echemedia.
It's old.
Yeah.
What do you want to do?
So we're set to plea or set it for trial today.
Correct.
I see some issues in the case. I've talked to my client. He is interested in possibly doing something different, but he is.
What other different?
We need an immigration concept. Well, possibly time served. But the thing is, the holdup is, I need an immigration consult.
That should have been done beforehand. I mean, today we're set plea or trial. This is not.
Right. And the only thing is,
No, we're now 215 days.
The thing is, I was only appointed like a month ago. I saw all these issues over the weekend. And so talking to him, see if he wanted to go to trial, he's like, hey, hold on, let's get an immigration consult, see how it's going to affect me. So
Okay, so I guess I'll give him till Monday.
the only thing with that is, Judge, this consult goes through the MAC. It's Miss Julie Pash. Today is Thursday. She's been getting on me about how backed up she is lately.
It's 215 days old, dude. I mean, it should have happened a long time ago.
Right.
You know, you can't just, it's on him. It's not on you. It's on him.
Yeah, I'll be straight with you, Judge. I don't know why I was only appointed like a month ago. I don't know if he was missing or something.
Correct. He's been AWOL for all that. So it's not, I mean, I'll give you a week, but that's it.
Okay, I'll let her know. I'll let her know, and hopefully she gets it done. Thank you, Judge. All right. Okay, cool. Thank you.
So that is very Texas. Texas, two states.
Pardo, come here. You, ahí. Tu caso ya tiene 215 días. Te voy a dar una semana para hablar con un abogado de inmigración para ver qué va a pasar. No te doy.
This courtroom session demonstrates how one judge can handle a wide variety of criminal cases in a single docket while focusing on the same core principle, protecting the community. Throughout these hearings, Judge David Fleischer reviewed probable cause, explained defendants' rights, issued bond conditions, approved plea agreements, and repeatedly reminded defendants that future decisions would determine where their cases ultimately lead. Whether the allegations involved reckless driving, driving while intoxicated, terroristic threats, criminal mischief, theft, or illegal street racing, the message remained consistent. Every choice carries consequences, and the court expects accountability from everyone who appears before it. These proceedings also show how bond conditions are used to reduce risk while criminal cases continue through the legal process.